I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for these lessons on state public record laws and the Federal Freedom of Information Act. This is the fourth round of lessons that all build on one another. First, we discuss the law itself, what it covers and how it can be used. Then, we invited a local journalist to share 3 specific requests they made and the stories that resulted. Our previous round of lessons focused on the appeals process, what to do when your request is denied. And now we again have a local journalist to share their experience using the appeals process to obtain records for their reporting. Links to all videos, as well as other valuable information, can be found at nefac.org/FOI guide. This round of lessons is brought to you by NEFAC with support from the Rhode Island Foundation, the SPJ Foundation, MuckRock, SPJ New England, and the New England Society of News Editors. Thank you again for joining us. Now, here's NEFAC's Emily Sweeney to introduce you to your instructor.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you for joining us for this webinar, which is part of our ongoing series on public records laws. With us is Callie Ferguson. She's an enterprise and investigative reporter for the Bangor Daily News, and she's going to walk us through what happened with her public records request, when it got denied, how it was appealed. And yeah, Callie, thank you so much.
Sure, thanks Emily, thanks for having me here. So again, thanks so much. I'm Callie Ferguson. I am an investigative reporter with the Bangor Daily News, and I'm going to take you through a story that began about 2 years ago and actually, for the most part, resolved about a week ago. So this is sort of a timely moment to be talking about this, but it's a story about how my newspaper, the Bangor Daily, teamed up with one of our primary competitors, the Portland Press Herald, to investigate collaboratively the discipline practices within Maine's largest police force, the Maine State Police, and how we also fought back against what we believed were some unfair, illegal redactions to discipline records. And ultimately, a judge validated our instincts a week ago. So I'll jump right in. So in May of 2020, again, a little over 2 years ago, I requested from the state police 5 years worth of disciplinary records. Now in Maine is a minority of states where discipline records for police are public documents. And this dates back to a personnel statute in Maine that applies actually to all state employees, not just police. Dates back about 30 years ago. Lawmakers were basically deciding how to strike a balance between protecting the privacy of people who decide to work for the public and in a public capacity, and government transparency. And they decided that, for the most part in Maine, personnel records for public employees would be confidential. But in the case where somebody was investigated for some kind of wrongdoing on the job and that was sustained and they were punished for it, that record of misconduct, or specifically of the discipline, would be public, because there should be some sort of public understanding and awareness around when there's some sort of public wrongdoing, and of course how the agency accounts for that. So here's my records request. You can see that I cite the statute that I just referred to. I asked for those final records of discipline. I also, you can see below, asked for settlement agreements. Just from previous reporting, I've known that some people resign in lieu of getting disciplined. So, that sometimes circumvents the transparency piece I just referred to. But settlement agreements are public too. So sometimes that can be your only record of maybe tracking someone's departure under questionable circumstances. I also noticed that one of my competitors, Matt Byrne at the Press Herald, he's their cops reporter, had requested some similar documents in the wake of George Floyd's murder, when a lot of people were talking about police accountability. He put together a very smart tweet thread about how difficult it can be sometimes and how time-consuming it can be to get police discipline records. And as an example, he mentioned that he'd requested 2 years of discipline from the state police earlier in the year and hadn't received them. So that stuck in my mind that he might also be getting similar records. As Matt pointed out in his thread, it can take a while to get these records back. So I didn't get them back immediately. The reason I had asked for them is because my team at the paper was already engaged in a different reporting project about Maine County Sheriff's offices. We were requesting 5 years worth of discipline from all 16 of Maine County Sheriff's offices because we wanted to get a sense for what their process was for handling discipline, if we learn anything about the type of misconduct that might be taking place among the deputies or in the county jails. So in the meantime, we ended up getting back hundreds, if not more than 1,000 disciplinary records from all 16 of those sheriff's offices, and ended up reporting out this series, which I won't get into very much, but I bring up because over the course of reporting that, and while my FOA with the state police was pending, we ended up getting very familiar with the nature of discipline records in Maine and how various law enforcement agencies, in this case specifically the counties, were interpreting their obligation under the law. And one of the key takeaways was that it was very inconsistent. So, for example, in central Maine, there were 2 neighboring counties, one of which produced in that 5-year period more than 150 pages of very standardized, very detailed discipline records for deputies and corrections officers. And in the neighboring county, they initially told us, well, we don't have any of those records. And, we thought it was maybe implausible or untrue that, there was absolutely zero discipline happening in counties that bordered one another. And after some hand-wringing back and forth, that county, Somerset County, eventually did find and produce those records after we'd initially published that series. So we were pretty familiar, like I said, with the difference and variation of just quality and quantity across the state. Some of the records were really detailed, as I mentioned. Some of them were very, very vague, sometimes so vague that it wasn't actually clear why the person was punished. So fast forward to December, after that county project is over, the state police provides the same type of records at the very end of the year. They provide a little over 50 pages of records, I'd say, for 19 different officers that had been punished during that 5-year period. For some context, that's state police is about 300 officers. So as you can see in my email to my editor there, I thought it would be more than that, but I had known by then that, there's a lot of variety with discipline in Maine. So here's the email from the state police's attorney, Chris Parr, forwarding along the records. And then below, in the lower right-hand corner there, I forward them to my editor, Aaron Rhoda, with 2 initial impressions of them. The first was that many of them were very vague, so vague that it was unclear why the officer was punished at all. And again, we were pretty familiar with these records at the time, and these certainly skewed way toward the vague end. In fact, of the 19 records we got, 12 of them were so vague it was unclear why the officer was punished at all. And the other thing that jumped out to me is some of them appeared to have been redacted in places in a way that I felt like we should push back against. So thus begins, well, here's an example, for instance. There was a 20-day suspension for a corporal. And as you can see, it appears that they kind of surgically excised the sentence that described what he did. So at the very bottom, closes his case, redaction. This is a violation of our code of conduct and vehicle use policy. Similarly, there was a sergeant who didn't work for an entire month unpaid for a reason that we didn't know because it was apparently blacked out. And again, it's hard to know what's under these redactions, but from these sort of records, the context suggested that they were blacking out the very nature of the misconduct, which again, the whole point of making these records public is so that the public can understand, what the wrongdoing is. And so these redactions seem to defy the spirit of the law and also the sort of letter of the law as well. So after this begins what I would describe as a steady escalation. So in Maine, if you want to formally appeal a FOA, you have to appeal it to Superior Court and it goes before a judge. That's an expensive option. Our newspapers in general, especially local ones, don't always have the resources to do that. It can be time consuming and whatnot. And we've had luck in the past by just simply asking agencies to reconsider their denial, or in this case, their redactions. So here's the first email we sent less than a week or about a week after we got those documents back to the lawyer, basically asking the agency to reconsider the redactions and explaining why. We provide some examples. we mentioned the fact that, we're familiar with, these kinds of records, and, we've very few that we saw with the sheriffs were redacted to this degree. Some of them appears they redact the actual misconduct, and some of them they appeared to redact like whole paragraphs, which again, Maine public records law, to comply with it, agencies are supposed to follow a redact and release protocol. So, if a document is public by nature but contains some information that may be subject to a confidentiality exemption, they're just supposed to take that little part out and give the rest. So, blacking out entire paragraphs, was suspect to us. And we also made it clear that, these records may contain information that we have no interest in and that should be confidential, such as social security numbers or medical information. And that's fine. But again, we had reason to believe that maybe they had aggressively redacted these documents. As a result, like I said, the lawyer actually did unredact some of those documents, but really not in any kind of meaningful way. It was just 2 paragraphs, and it wasn't, they didn't unredact any of the documents that actually revealed more information about the misconduct. For the most part, it didn't really change anything for us. In addition to the redactions, I was going through this pile of records a little more closely and found that they were very inconsistent in how they looked. And I had reason to believe that there may have been documents missing from them. And I guess the best way of describing that is some of them kind of looked like memos. Some of them looked like these consent agreements between the union and the officer, sort of almost like a meta document around the discipline. And those documents would make reference to memos of discipline. So I was kind of curious, well, where's that memo of discipline that I feel like we should be entitled to? For some officers, we just got that settlement. For others, we just got the memo. For some officers, we got both. So it was kind of confusing. Some of the records were unsigned. So we're like, is this the official document or not? It just, at best, it kind of seemed sloppy. At worst, felt like there were holes in the batch of records that we got. And it was around then that we realized that the state police union agreement has a provision that allows the agency, after a certain period of time, to remove disciplinary actions from a trooper's personnel file. So we wondered, well, were more than just 19 people disciplined during this period of time? But those disciplinary measures were taken out of the batch, and should we get those too? These are all a lot of good questions, I thought. So I tried to reach out to see if I could talk about them with the state police's lawyer. You can see that he only agreed to talk over email, which I only kind of include to say that this back and forth, our pursuit of kind of understanding wasn't just with regard to the documents, but also was kind of hard to interact with the agency during this. I ended up putting together a long email where I kind of went point by point through each record, asking, should there be another document associated with this? Basically trying to interrogate questions around the sort of adequacy of their search for documents and why the records looked like this. And I didn't get an immediate answer to this. At this point, me and my editor, Erin, were considering whether or not we should escalate this further. And we decided to have our lawyer send kind of a strongly worded letter. Again, we weren't sure if we were going to sue yet, but we thought maybe the sort of threat that we might, or implication that we were taking this very seriously, might change things. We sent the letter, it did not. This here is a letter that the state police sent back explaining why they had redacted this information. They said that the redactions referred to medical information, which is one of the exemptions to our public disclosure laws. That is fair. And again, like we said, we weren't totally interested in. Proposed discipline that was not ultimately imposed, information that implicates Garrity protections, which is Garrity protection is basically protects an officer from making a statement that would, an incriminating statement during an IA investigation, and information that describes the misconduct in greater detail. And could potentially, I think they're referred to a complaint that had been made but not substantiated. And he also said that he wouldn't say which reason referred to each redaction, because in doing so, it would sort of give away what was underneath the blacked out portion, which, typically it's one of the first questions I ask when something is denied to me. I'm like, where explain to me exactly why I can't know this thing. So it sort of further frustrated us. And it's at this point that we were really considering filing a lawsuit. And in doing so, we wondered if down in Portland, the Press Herald was wondering the exact same questions that we were, because as I mentioned before, I knew that one of their reporters had asked for similar information. And we decided, though it's very unorthodox for us as rivals, to reach out to one another about what information we had gathered that could, result in a story. We decided to reach out and ask, if they had received these records, if they were wondering the same things, and if they were considering an appeal. And we decided ultimately through that conversation that we would, though unorthodox, put our rivalry aside and file a joint appeal in Superior Court. And I think it's also worth mentioning that we had support in doing this from the Pulitzer Center, and the Yale First Amendment Law Clinic decided to help us as well. So we had other support that sort of eased the cost of doing this. And I think also was sort of a show of solidarity in what became also kind of a statement about transparency. And here's our complaint. This is actually the Press Herald's complaint, but there was a quote in it I liked from their lawyer, Sig Schutz. The interest in public access to public employee disciplinary decisions is particularly compelling when the employees in questions are law enforcement officers vested with great public authority, including the power to make arrests, detain citizens, and use force. Public awareness of whether law enforcement agencies are engaged in effective oversight and discipline of officers serves as a vital check on police corruption and misconduct and interest at the core of what FOA is all about. So again, I think that sort of summed up sort of our argument as to why we think we should know what's behind these redactions. So in the meantime, lawsuits take a while to win their way through court. And we had already sort of been conferring about with the Press Herald about what to make of these documents. And we decided to collaboratively do an investigation about the state police's disciplinary process, and sort of dig into the other records that we had at our disposal, specifically that vague language. We ended up co-reporting a 3-part series, the first of which sort of centered on this secrecy that the agency has a reputation for, the stakes associated with the opacity of their discipline records, among other kind of themes and whatnot. And then we also decided to see if for every super vague discipline record, of those 12 records for which we could not understand why the officer was punished, we wanted to see if we could actually figure out what happened just using the tools of journalism. So one of the stories was just that. Of those 12 records, we were able to figure out in 7 cases what actually happened and show that in some cases, the state police was actually sort of punishing their officers fairly lenient for what experts called pretty serious misconduct. And then a third story that Matt reported, you can see here, was actually about a trooper for which we had no discipline record, but knew had resigned under criminal investigation for domestic violence. So that was in April of 2021. Like I said, it takes a while for lawsuits to move forward. So it wasn't until January of this year after this whole thing started, that we had, or year after we got the records back, that we had our day in court. We basically, the arguments on our side centered on the themes that I've gone over, that we feel entitled, that, these final written records of discipline are public under the law, specifically descriptions of discipline, and that often that should be, weighed and balanced with privacy, but we felt like they were aggressively redacting these documents. And just last week, a Superior Court justice in Bangor, for the most part, sided with us and said that, yes, some of this information was redacted, was not redacted for just and proper cause. Here's our story from that. He let stand 4 redactions that specifically referred to medical information or the work performance of another officer. So what was revealing about this is that, yes, in some cases, we did learn new things about misconduct, and our instincts were right. They had blacked out what was alleged or what misconduct was at issue in the discipline. But in some cases, we learned that they also redacted information that was kind of vague or even boilerplate. So, for example, that 20-day suspension for a corporal I mentioned before, it turns out they had redacted this middle sentence. The case alleges in July 2019, you misused state property by artificially inflating your speedometer reading on your cruiser to present a false mileage report. So, that's fairly serious, I think, manipulating your mileage and then having the state pay for it and then lying about it too. I mean, the sort of honesty of officers in their treatment of taxpayer funded equipment, I think is, a pretty serious thing. So that was revealing to learn that. But this second paragraph about Trooper Kofleski, to me, that reads as a fairly boilerplate sentence that's included in some shape or form on a lot of these discipline records, but they had blacked it out in its entirety. So, and then here, this last one, referring to a sergeant, actually the supervisor for this corporal's troop as well. They blacked out a lot of this language about him sort of failing to notify his superiors about some misconduct and giving bad directions. But even with the redactions taken away, it's still kind of unclear what's happening. So it kind of reinforced some of the key takeaways from our investigation a year ago that this vague language undermines the spirit of this public disclosure law. And then last, and this is still sort of part of the judge's order we're waiting on. The judge also agreed that the search for records was inadequate in that, again, there appeared to be these missing records and the state couldn't really answer, at least in court, whether or not they existed. And he ordered the state to perform another search. So I think that's for the most part. We're still waiting on, again, if that extra search turns up any more records. But, in the end, even if the lifting of these redactions, for the most part, reinforced a point that we made a year ago that the state's failure to be transparent about officer misconduct and also how it holds those officers accountable is something that undermines, one of the core principles of, our public records laws. I think it's reignited a conversation that started a year ago, and we've already been in talks with lawmakers who say that they want to do something about this. So it was a victory, I think, in that push for more clarity around police accountability. So we feel very happy about that.
Callie, thank you so much for taking the time to do this. It was a great presentation, and I learned a lot, and I know everybody else that participated in it too. So thank you so much, Callie, and thanks everybody for tuning in.